Subscribe to our YouTube channel and don't forget to press the bell icon to get all the latest updates. Prashant Bhushan has said that he will respectfully pay the 1 rupee in fines that the Supreme Court has asked him to do so after finding him guilty of contempt. But many people believe that this is a moral victory for Mr. Bhushan, who refused to apologize though asked by the Supreme Court to do so. What are his learnings from this moment? And his party is talking about this being a national movement to, in fact, raise money for a national legal fund. Joining us now is Prashant Bhushan himself. Mr. Bhushan, describe a little bit your sentiments leading up until this point. Was it a very difficult decision for you to decide not to apologize? Because the court could have gone either way. In the end, it only imposed a token punishment, but it could have sent you to prison. This has been known to happen before. So were you conflicted about what position to take?
No, I was not conflicted. Initially, a little apprehensive to be candid about it, about the consequence of going to jail. But my father has always taught me that look the devil in the eye. Think of the worst that can happen. Think about it carefully, and then see whether that is something that you can take care of or manage, so to say. So I looked the devil in the eye and I said that, all right, even if I have to go to jail for 6 months, what will happen? I will spend time in prison like many others have done. My grandparents, even my father has been in jail, though only for a week and not during the emergency. It was the emergency for some civil disobedience. So many people, so many of these activists have been in jail. All these Bhima Koregaon people have been in jail for 2 years. So what's the big deal? Okay, it'll be a little tough, but I'll use that time in some productive way by way of reading, writing, seeing how life is in prison, interacting with people there, etc. And once you have confronted that fear, then you are at peace and then you are liberated. So therefore, thereafter, I was not particularly worried about what they might do, because I had looked at the worst possibility.
I should say that when you say you were ready to look the devil in the eye, the devil here is metaphorical and not literal, lest you be hauled up for contempt all over again.
No, the devil is the worst possibility. Yeah.
Yes. No. But on a more serious note, Prashant, the fact is that there are some who wanted you to not even pay the 1 rupee. These included people on the right wing who do not like your politics, but they also included some of your own admirers who wanted you to push the envelope further, who wanted you to say that, go to jail, don't even pay this 1 rupee fine. So was there some part of you that thought that I won't even do this and I'll go to prison? Was there any part of you that wanted to do that?
No, it wasn't, because you see, it was not as if I was itching to go to jail. I was prepared to go to jail. And here the court had imposed a 1 rupee fine on me, which is, of course, also not quite fair or correct. I should not have been held guilty of contempt at all in the first place, which I will challenge. But I said that, yes, I'll pay it under protest, because it's not as if the only way that I can make my point stand by what I have said is by going to jail. I said that I'll accept any punishment that they impose on me. Obviously, I have to. The Supreme Court is final and supreme in that sense, subject to my right to file a review or a writ petition against this judgment. I'll accept it. The penalty was 1 rupee fine.
Yes.
So I said, okay, I'll pay that.
And you have decided, I gather from your previous answer, that you are going to challenge this conviction.
Yes, of course. You see, there is not only a review, but in my view, even a writ petition saying that there should be some intra-court appeal which should go before a different bench, that writ petition will also be filed, because the Supreme Court has held in several cases that at least one appeal against a criminal conviction is a fundamental right. Now, this is an original conviction by the Supreme Court. So there should be a regular appeal to a different bench. Review goes to the same bench. So I will file a writ petition also saying that they should devise an intra-court appeal or convert the review in this case into an appeal which goes before a different bench.
Let me ask you this. The Supreme Court clearly pulled back from the brink or was persuaded to do so after a 108-page judgment finding you guilty. It finally imposed really a token rap on your knuckles. Were there people in the middle who had opened a back channel? Were there well-wishers who persuaded you also to be somewhat more reconciliatory? And if so, are there things you've done before that you would not do again? For example, would you tweet the same thing all over again?
No, I don't. There were no people in the back channel so far as I am concerned. I don't know what weight with the court, because if you read this sentencing judgment, almost till the end, it's a very, very strong and fairly vicious judgment against me. But at the end, it just stops short of imposing any vicious punishment or any harsh punishment on me. It imposes only a 1 rupee sentence. So I don't know what eventually weighed with the court or didn't weigh with the court. So far as my doing or tweeting as the same or similar things is concerned, you see, I have always said that it is the highest duty of a citizen, and especially an officer of the court, who is a well-wisher of the court, to say and to speak out when the court is going wrong or going astray or not doing its constitutional duty. And that's what I did through those tweets. Now, many of my family members have urged me to be more cautious when I tweet, etc. So maybe I will be a little more cautious. But those tweets, especially the one about what has happened to democracy in the last 6 years and how the Supreme Court has kind of allowed the erosion or destruction of that democracy and the role played by the last 4 Chief Justices, that was a very, very well considered and well calibrated tweet. And that kind of thing I will certainly say in future also, if I see any occasion for that to be said.
So you stand by the content of those 2 tweets for which you were found guilty?
Yes, absolutely. The only thing that I regretted was having said something about the helmet, because I didn't notice that the bike was on a stand and therefore no helmet was required. See, the main thing about that bike tweet was that I was saying that, look, here is the Chief Justice who has kept the Supreme Court virtually in a lockdown, where there are only a few cases being heard, and that too in a very unsatisfactory mode of e-hearings or video hearing, which is not a very satisfactory mode at all, because today also in my hearings, they couldn't see me, they couldn't hear me, you are not unmuted, sometimes your connection goes off. And so it's a totally very, very unsatisfactory mode of hearing, and very few cases are being heard. So, the Chief Justice had himself said that because of this lockdown of the Supreme Court, lawyers have been deprived of their incomes and so on. Bar Association had passed resolutions against the lockdown of the courts. And therefore I said that here is, on the one hand, the Chief Justice who has kept the court in lockdown. On the other hand, he is in a public place with people surrounding him, sitting on a bike without a mask. This is very, very incongruous, and I was anguished by that. Anguished mainly by the fact that the court had been kept in lockdown.
People have pulled out some of your old tweets from a time when Justice Karnan was sent to jail for contempt of court. And they have said, look, Prashant Bhushan, when the shoe pinched you, you protested against the criminalization of contempt, but you yourself in the past have supported it. When you look back at that case and you look at your position then, do you still believe you took the correct position. There has been commentary that has even brought in Justice Karnan's caste, your relative privilege into it. I've seen some of that commentary. But there's a larger question. Is this not an archaic law that needs to go?
See, contempt consists of three parts. One part is civil contempt, that is disobedience of a court order. That is perfectly fine. It should be there. It's meant to ensure that court's orders are obeyed. The second is criminal contempt, which is also divided into two parts. One is interference with court proceedings or with the administration of justice. So if you start dancing on the table in front of the court and don't allow proceedings to proceed, or if you threaten a judge that I will kill you if you decide against me, or if you threaten a witness, I will kill you if you depose against me, that is interference with the administration of justice. And that certainly should also be a contempt which should be punishable. The third part is the problematic part, which is scandalizing the court or lowering the authority of the court. Now, this is very vague. What scandalizes the court, what lowers the authority of the court. And since in this jurisdiction, judges often sit as judges in their own cause, which means that if you have said anything against the court or against any judge, they feel scandalized or they feel hurt, and therefore they initiate contempt proceedings for scandalization against you. This is the part which needs to go, which has gone in all civilized countries, except India and one or two other countries. And that's what is problematic. Now, in Karnan's case, in Justice Karnan's case, it was not scandalizing. See, he had been passing orders from his house, from his court, which were clearly beyond his jurisdiction, saying that these judges of the Supreme Court must be arrested and brought before him, that these, etc., etc. So therefore, that clearly had interference with the administration of justice. It was not merely scandalization, it was clear interference with the administration of justice. Now, whether he had been sent to prison for that, he should certainly have been punished for that. He should certainly have been prevented from repeating that. But whether he should have been sent to prison or not is an open question. Maybe he should not have been sent to prison. That was perhaps not required. But that was a different category of contempt altogether. That was not just making some.
Another point that the Supreme Court has made is that they do not have recourse to the media like you do. Like, you can go to the public, you can talk to me, you can talk to other journalists, but they can't. And they look back at that press conference in which Justice Gogoi was also sitting there as something that should not have happened. How do you respond to the Supreme Court's concerns that you went very public with what you thought, and they don't have the same access, so to speak, to the public domain?
So firstly, you see, judges speak through their judgments. And their judgments should speak for themselves. And that should be adequate defense for what they have done. Ultimately, you see, this view that the reputation of the court or confidence in the court can be propped up by preventing people from criticizing the court is a totally wrong-headed view. The confidence of the people in the judiciary or in judges or the courts arises from their actions and their own behavior. If somebody makes any unfair criticism, etc., of the judiciary or any judge, that is normally seen for what it is. It is only when a criticism is fair and it comes from a responsible person that criticism affects people. It may in that sense affect the confidence of people in the judiciary. It could, but that is necessary for correcting the judiciary. For any act of correction, wherever the judiciary is going the wrong path, that kind of criticism is necessary. Now, it's not that judges themselves have to respond to any criticism. There are always people who respond on their behalf. There are other lawyers, there are other people, there are retired judges who respond on their behalf. If there has been some unfair criticism leveled against a judge, other people respond on their behalf. So there is no difficulty about that.
In the end, let me ask you about the political space that you seek for yourself. Your ideological opponents would classify you as extreme left of center and say that you're in politics, but you don't have the pulse of the mainstream. How do you respond to that, and do you see yourself remaining in electoral politics? Because many people see you as too much of a puritanical extremist to be in electoral politics.
No, I don't see myself as being in electoral politics directly. That's not my cup of tea. You are right that I am not given to diplomatic niceties and my utterances, in my so-called political or non-political behavior, etc. I certainly want to influence the politics of this country. I want to influence how things are happening in this country, what is happening in this country. But I don't want to do it by directly getting involved in electoral politics. You are right that I am somewhat left of center, as it is called. I don't see myself as left or right, etc. I just say that everybody obviously sees things from their own lens. I also see the world from my own lens. I come from a very privileged family, a family which cannot be called left-wing, or the views of this family are not left-wing. But over the years, because of my interaction with so many people, struggling people from tribals, rickshaw pullers, street vendors, etc., I have come to realize that the system of this country is unfortunately very, very heavily weighted against the poor and heavily favors those who are very privileged. So in that sense, I feel angry when I see some great injustice being done to these poor people. And in that sense, I can be called left-wing or somewhat left of center.
In conclusion, would you care to comment on the surprising position, some would say, taken by the Attorney General, who did not want any punishment for you? Subsequently, he also denied permission for actor Swara Bhaskar to be tried for contempt. How did you read Attorney General K.K. Venugopal's position on this? And what is the import of this moment, this ₹1 fine? What is the importance of this moment?
So I was very gratified with the stand taken by the Attorney General, Mr. Venugopal. For once we saw somebody standing up as a constitutional officer rather than a lawyer for the government. I see this whole contempt case as two things. Firstly, it has brought the focus and the spotlight on the role, on what has happened to our democracy in the last 6 years, what the role of the court has been, etc. And in that sense, I think this focus is a very useful focus, which would help and which should help the court in correcting its course. Also, it has become a kind of watershed movement for the freedom of speech in this country. And a lot of people have taken it up like that. A lot of people were willing to repeat those tweets and say, okay, all right, if you want to punish Prashant Bhushan, you punish me as well. And ultimately, I think it will lead to people becoming bolder and more emboldened on speaking out on critical issues facing the country. I hope it will have that effect.
Well, I think it certainly has given people a belief that there is still dissent and free speech and the right to free speech alive. Thank you so much, Prashant Bhushan. Thank you so much for talking to us.